welcoming back to the program, been here many times, Mark Joseph Stern. He's a senior writer at Slate, focusing on the courts. And Mark, welcome. I feel like we're going to be doing this like with just such a wide range of cases over the course of the next, I don't know, maybe, I mean, God willing, we'll be doing this for the next 15, 20 years. I mean, or I should say, God willing, that we'll be able to do this, but maybe we won't have to. All right, let's just start with let's start with the affirmative action case that took place now, I guess 2 weeks ago, maybe, or at least the oral arguments. These are two different cases. One is the University of North Carolina, and one is Harvard. Both of them in these instances are the defendants, and they were brought together because some of the issues are similar. And we should say KBJ had to recuse herself, I think, for the Harvard one, not the North Carolina one, because she had sat on the subsidiary court that had first heard it, and before it came to the Supreme Court, as far as I recall.
It's actually that she sat on some board at Harvard because she had a professional connection there. So she felt she had to recuse. That's the kind of ethical standard that someone like Clarence Thomas couldn't possibly understand. It
really does feel like that's like, I mean, there's really different standards, and one wonders, you know, I mean, I appreciate that she's exercising that. Maybe it does like just shame him slightly, but I doubt that.
I don't think he's capable of shame.
All right. Well, so walk us through, like, there has been a long-standing precedent for the existence of affirmative action, which essentially arose in the wake of the civil rights fights in the mid-'60s, where there became an awareness that, like, we need diversity in particularly in colleges. Take it from there.
Yeah. So on 3 separate occasions, the Supreme Court has held that affirmative action is legal, 1978, 2003, and 2016. And on all 3 occasions, the court held that what you just described, diversity in the classroom, that is a really compelling interest because students gain all kinds of good stuff from having different viewpoints, different backgrounds, different people surrounding them in a classroom. And that colleges and universities, they can't have some kind of specific racial set aside, a quota. They can't say, oh, well, you must have 15% Black, 15% Hispanic, whatever. But the court said, if it's just one of many factors, if you're still undertaking a holistic review, then it's perfectly acceptable to consider that when building a new student body so that everybody is exposed to people who aren't like them and they get the educational benefits that flow from that.
And so it's, you know, we could say like 10%, are you rural or urban in terms of like where you've lived? And the idea is not that you necessarily, if you're rural, or you come from a rural area or urban area, you're going to necessarily, it's going to help you. It's going to be a function of how many other rural people do we have? How many other urban people do we have? We want some type of like balance and representation. And that goes for a whole host of socioeconomic factors that go into that, which makes sense. And it also means that regardless of whether you're rural or urban, or whether you're Jewish or Muslim or Christian, or whether you are Black or white, you're going to benefit from this diversity in the same way that everyone else is. This is not necessarily, I mean, from the individual, it may have different implications, but as a student body, everybody benefits from this.
Everybody, according to previous Supreme Court decisions, according to a lot of sociological data, everybody just benefits from exposure to all kinds of different backgrounds. It opens up their minds, especially young people who may have come from very homogeneous backgrounds. It's good for them in a classroom to hear from folks who had a different life experience than they did. And I think the rural-urban example is a great way to kind of drain the politics from this and look at it in a more neutral way. You probably don't want to be in a classroom of exclusively urban folks who grew up in New York City just like you. If you're in college, you want to hear from people who had different experiences before they arrived in that classroom. And the same theory applies to race and ethnicity. You don't just want to be surrounded by a bunch of white kids. You should be exposed to people of different skin colors, of different ethnic backgrounds, and hear from their lives and their experiences, and perhaps even open your mind to different ideas because you are forced to talk and reason with them.
And so we played a couple of clips, if I remember correctly, from the oral arguments. One was a great clip that from KBJ, where she was talking about University of North Carolina. And what was interesting is this is ostensibly about the 14th Amendment in some ways, but the conservative justices didn't seem to address. All right, will you, before we get into the specifics, will you talk about that dynamic? Because it's fascinating, because they're the textualists, the originalists. These are all made up things, incidentally. I don't really buy into that, those things. They are when they want to. But this is a perfect example of where they weren't even looking at the Constitution. They were looking at outcomes, and KBJ was looking at the Constitution in this instance. Will you just talk about that generally, and then we'll take it down to a more granular level?
Yeah, so these arguments went on for about 4 hours total, and it took almost 2 hours for the justices to actually start talking about the legal theories rather than the policy disputes here. And it was Justice Elena Kagan, Justice Sotomayor, and Justice Jackson who really pushed the court in that direction, because up until that point, we had had people like Gorsuch, Alito, Roberts, Thomas complaining about all of the allegedly terrible things that affirmative action does. It reduces people to a stereotype. It, it just factors them by their skin color and nothing else. I mean, you can make policy arguments for and against affirmative action, and I think have a kind of reasonable basis on both sides. But that is not the Supreme Court's job. The Supreme Court's job is supposed to be to apply the Equal Protection Clause in this case and decide whether these institutions ran afoul of it. And that was not the focus of the conservative justices throughout all 4 hours of arguments. They were focused on airing their own grievances and hurt feelings about affirmative action, and really relegated the Constitution to a second or third hand consideration.
Now, I am, I think, a little bit more amenable to the sort of like the policy arguments on some level, just in general, right? I'm talking generically speaking. I was a critical legal studies type of person. I mean, but will you just, when you say there's a difference between policy and legal arguments, will you, like, in general, talk to people who don't maybe aren't clear on what that distinction is? I mean, I am somewhat, I guess, more sympathetic to the idea of policy things coming out. That's sort of like that Brandeisian brief, if you will. Like, what are the real world implications of this when we do it? I just happen to think that the policy outcomes are actually good ones. They have a slightly different feeling about it, but it is just odd for them who have completely built their entire legal branding on the backs of completely disregarding the idea of policy outcomes as the issue.
Right. I mean, this is a long-running debate throughout all of American history. What are the federal courts supposed to do? Are they supposed to apply some general sense of fairness? Are they supposed to interpret the laws in the Constitution in light of what they think is better for outcomes for the American people? Are they just supposed to apply the law as written, as originally understood, and let the chips fall where they may? So, somebody like you'd probably say at the end of the day, this is all policy, right? At the end of the day, these justices are going to reach their preferred conclusion and then find a way to explain that on the basis of constitutional theory. And I think that is a perfectly valid argument. What conservative justices have said for the last 30, 40 years is that considering policy in a judicial decision is off the table, that is a totally unacceptable approach to doing law, because a court's role should be limited and narrow. A court should simply look at the text of the law, look at the original meaning of the Constitution, apply that, and move on to the next case without any consideration of how it will affect the people of this country or of the entire world in some of these cases. And so this is, I think, a really important debate to suss out in a case like this, because it's the conservative justices who oppose affirmative action, right? And it seems pretty clear that they oppose it on policy grounds. Yet they are the ones who have been saying for so long, policy is irrelevant to judicial decision making. We should only consider the public meaning of the Constitution. And in this case, if you look at the original meaning of the Equal Protection Clause, it is very difficult to identify any kind of bar against affirmative action or what we call race-conscious remedies. In fact, it looks like the people who wrote the 14th Amendment and the Equal Protection Clause after the Civil War wanted to enshrine certain race-conscious remedies into law to ensure that Black people could be brought up to the same legal standard as white people all throughout the country.
The entire impetus to write the 14th Amendment was because they were conscious of disparities in races coming out of the end of the Civil War. And this is why we're writing this 14th Amendment, so that it will, in some ways, hopefully, slowly even the playing field on some, like it is a function of maintaining an even playing field. All right. And just to get back into that distinction between like sort of my cynicism and critical legal studies perspective on this and the sort of originalist textualist, there's a middle ground there, right? Where most sane jurists, I think, inhabit, which is you can't, like the situation when the framers wrote the Constitution was they all had slaves. So you can't literally take their intent there, or if you did, then, there'd be second-class citizens, or at least that would be fine. Or, right? I mean, like, there's no way to do what they claim to do.
I actually think there's an even deeper problem than that, which is that if you ask a real historian, like someone with a PhD in history, whether history can provide a definitive answer to most major legal questions of the day, they would say no. That's not what history is there for. History can provide some evidence about how people felt one way or the other. History very rarely provides one single objective correct answer in any of these cases. And so in the current dispute, you can go through the record and find some members of Congress who passed the 14th Amendment who did talk about wanting a colorblind constitution. You can also find a bunch of members of Congress who said the exact opposite, who said we need to consider race so that we can bring Black people up to the level of white citizens. And you just can't find from all of those debates one single answer that you can apply and say this is the true constitutional meaning, because history doesn't work that way. And so I just think a sane judge, someone like Elena Kagan or KPJ, they are using history and text as two tools in a broader toolkit. They are asking, what is the broader purpose of the Equal Protection Clause? What is the broader meaning of the 14th Amendment? How can we use history in context to figure out how all of this resonates in these disputes today? And I admire that kind of judging, because I think it's much less arrogant. It does not rest on this notion that you can hold a seance with the framers of the 14th Amendment and learn exactly what they meant. All you can do is make your best guess about that and hopefully factor it into a broader, coherent, and stable jurisprudence of equality.
So KBJ at one point said, in terms of like the 14th Amendment, like if you said to the plaintiff in the North Carolina case, it seems like you might have an equal protections problem if we follow your prescription, because you could have a kid who applies to UNC and says, 5 generations of my family have gone here, and I want you to consider that, like, my relationship to the university. This has been a tradition in my family, and it's going to bring something to the community, and it's why I should get in here. And then a Black kid could be applying and be like, well, that was not, there's no way I could have ever been here for 5 generations, because up until even in the 50s, there was like basically an apartheid, when it came to that school. And I can't, you're denying me the opportunity to bring in sort of my family story, which is like, we were fundamentally kept out of this school because of who we were. And that's, so her argument was based on the 14th Amendment. What were the other people arguing? Like Sam Alito was basically saying, I can't even remember what it was, but it was really disturbing.
I mean, I think Alito has really latched on to one of the main theories in this case, which is that affirmative action discriminates against Asian American students. And that's what John Roberts said as well. That's what the plaintiffs are arguing. I think it's notable that in these cases, there was a full trial held. In the case of Harvard, a very long trial with extensive evidence produced on the record that showed that the school was not discriminating against Asian Americans, that it was not actually unfairly biased against Asian American applicants. But, these justices don't really care. They think the trial didn't matter. And so they are making this kind of sideshow argument that draws us away from the real dispute to say, well, even if this could in theory be done well, it always ends up discriminating against Asian Americans. And that leads to their broader argument that these laws and these practices and programs, they flatten people on the basis of skin color, on the basis of race, that it transforms them into nothing but one particular race or another, and that gives them a leg up or a leg down. And I think KBJ was pushing back against that by saying, actually, it's not just about which box you check on your application. A lot of these issues boil down to who you are as a person. And for Black people, for Hispanic people, their race may have played a major role. They may want to write in their application essay about how being Black has given them a lot of understanding of adversity in this country. And if the Supreme Court says that race is an unconstitutional consideration, well, then those people cannot write about that in their essay anymore, or universities cannot consider that anymore, because whiteness is invisible and racial minorities have to go up against that and try to figure out how to express themselves without describing their race. So it's a real quandary, I think, and it just points to what's going to happen after this decision comes down. If the court outlaws boxes that you check to signify your race, that will not be the end of the affirmative action dispute. We are going to be dealing with this for many years to come, because applicants will want to explain how their race plays a role in their life and their education, and judges like Clarence Thomas are going to want to say, well, you shouldn't do that, and that's unconstitutional.
It was Alito was talking about, like, how are we going to prove that people are really Black? And he used the example of, like, what if it was, he was, I guess in some way he thought he was mocking Elizabeth Warren by saying, what if it's family lore that part of my family is Native American? What percentage or how far back can you go to qualify as a certain race? Which, of course, my daughter's going through the college application process right now, and as far as I can tell, none of it's verified. None of it's verified. I could say that we could have a reference from a music teacher saying she is a wonderful student, and really, maybe she's not. Maybe the music teacher is just likes us, whatever it is. None of this is verified.
Right. And your GPA often isn't even verified, right? I think there's a real problem of people modifying their transcripts and sending it off. But all of this is just like a policy dispute that we've fallen back into. We've fallen back into these policy arguments, right? About, what about one-drop rules? What about Elizabeth Warren pretending to be Native American? Look, that is something for the UNC Board of Regents to decide if they want to crack down on. That is not an issue that the Supreme Court of the United States should be concerned about at all.
So we get a sense of where this is going, right? We won't find out till June, but it doesn't look good for, at least as constructed now, universities' ability to consider race as one of a multitude of factors that they consider when they admit someone into their school. Let's talk about, we'll get to Talevski. We've spoken about that in the past, but there was an argument the other day. But before we get to that, let's talk about Brackeen v. Haaland. This is a case that is not getting a lot of attention, it seems to me, in the sort of like, broadly speaking in the media, but it really it can seriously implicate the lives of many, many Native American children.
Of many Native people more broadly. And I think it's worth noting this is a case about child adoption, right? It has drawn the attention and support of almost every major conservative corporation and law firm in the country, who have all weighed in against Native people and Native families and on the side of white families who want to take these children away from their tribes and essentially assimilate them into white culture. That's not a surprise, because the conservative legal movement has been attacking what we call Indian law for many years now. Why? Well, Indian law protects reservations and tribes from a lot of corporate exploitation and state exploitation. It protects the states from basically seizing these children from reservations and adopting them off to white families. And it prevents states and corporations from buying or exploiting land that tribes are located on and taking natural resources like oil that happen to be under them. And so this is actually about a lot more than just adoption. That is kind of the entry point for a case that's really an existential threat to Indian protections more broadly.
All right. And I just want, I want, before we get into the details of this case, I want you to just sort of make this more clear, is that the idea is that if certain principles can be established in this case that has to do with adoption, they can be carried over into cases that just simply have to do with native rights over property. And therefore, you're getting corporations involved in something that has really nothing to do with them on its face, but they are looking to develop principles that can then be carried over into these other cases that have to do with just about money and exploitation of resources.
Yeah, that's exactly right. So look, the central argument in this case
Can
is
we
that
just say, like, stop here for a moment and just like, people have to understand just like how twisted and warped this is. And this is the thing, I think, you know, from a legal perspective, like, this is the way things are done. You know, a case that was decided 14 years ago and something written in the dicta or in the dissent by, you know, one judge can be relied upon by an entire court 15 years later to completely upend something. I mean, we sort of saw that with Dobbs in some respects, although it was more wholesale, just whatever. We're just going to do whatever we want. But that's what's going on here, is that the way that lawyers and the law is constructed, principles that seemingly have no relationship to a hypothetical case in the future end up being very important to that case.
Yes, that is exactly how this works. That is why Clarence Thomas was writing about the Second Amendment in the 1990s when nobody was paying attention. And then 15 years later, the court transformed his, you know, individual writings into the law of the land. So look, the central argument in this case is that it is unconstitutional, a violation of equal protection, for the federal government to classify people on the basis of Indian status. Now, there's a couple of problems with that. Problem number one, the Constitution itself classifies people on the basis of Indian status. This is something that is written into the Constitution. Problem number two, the Supreme Court has said for many, many years that Indian status is a political classification, not a racial classification, because what it actually asks is whether you are an enrolled member or a potentially enrolled member of an Indian tribe, which is sort of like having nationality in another country. Right. Yes, it has a corollary to race. Yes, if you're a Swiss citizen, you probably are descended from white people. But it is not classification on the basis of race. But because the court has been so hostile to Indian law over the last 2 years, basically since RBG died, these corporations think that they can destroy this entire body of federal law that is protecting tribes from exploitation on the basis of their Indian status. That is, for instance, tribes cannot just sell their land to corporations. States cannot seize tribal land the way they can private land. There are all these rules and regulations that protect tribes from abuse. And one of them is, in this case, states can't take Native children away from their tribes and adopt them off to white white families. Now, the central argument in this case is that that law is unconstitutional, that classifying children on the basis of Indian status is unconstitutional. But it's not going to stop with kids, right? We all know that this is laying the groundwork for future cases that give states and also private companies these long sought after rights to start attacking tribes more broadly. And so I wish this case got as much attention as it deserved. In some ways, it's more important than the affirmative action cases. This is about destroying an entire segment of federal law protecting tribes and their members and opening them up to the kind of abuse and exploitation that went on for far too long throughout the 18th and 19th centuries.
So what are they looking for? The argument being that that states can have an overriding interest, or that essentially these treaties and what we've written in the context of the Constitution are they're not sacrosanct, I guess, and that there are, as long as once you develop the principle that there are circumstances where we can supersede this, then it just becomes ultimately a negotiation as to what the circumstances are.
Right. I mean, look, this is all just replaying the fight that went on in the 1820s in this country when states started seizing tribal lands and the federal government tried to stop them. And states said, no, you won't, which eventually led to the Indian Removal Act. The state of Texas, which is an actual plaintiff in this case, says we don't want to have to abide by federal Indian law. We are a sovereign state and we deserve the right to control our adoption process, to regulate tribes within our borders and their members. We don't want the federal government with its stupid treaties and laws and regulations to get in the way of our sovereign interests. That is exactly what the state of Georgia said in the 1820s when it started to abolish Cherokee tribal councils and seize Cherokee lands. There's nothing new under the sun here. It's just that Texas has much better lawyers today than Georgia did in the 1820s.
And we should say that the reason why Indian law is essentially, or that relationship is ensconced in the Constitution, is because they found that under essentially the Articles of Confederation that it doesn't work. Like, you can't have two entities that are dealing with what is essentially another sovereign nation or a series of other sovereign nations. Can't have the states interfering here any more than, like, we can have the states saying, well, we've cut a different treaty with Mexico, or we've cut a different treaty with Canada than what, they've done, those pencil neck geeks in Washington have done. You can't have that.
Yep, that's right.
I mean, so this was explicitly to say states don't have authority to do this.
I know that I just said history doesn't provide right or wrong answers, but this is one of those rare instances in which history provides what comes very close to a clear answer. Like you said, Articles of Confederation split regulations over Indians between states and the federal government. Doesn't work. States start seizing tribal lands. Constitution says, okay, we aren't doing that anymore. We're withdrawing this power from the states. They don't get to regulate tribal affairs. Only the federal government gets to do this. And here we are in 2022, and the state of Texas is basically arguing that the Articles of Confederation should still govern this area.
Let's move on. What was your sense? I mean, where are we with that case? That was argued, I guess, on election day, right? Was it on the 8th?
The day after election day.
Okay.
So Gorsuch is really good on tribal affairs. If we only had RBG back, this case would be a slam dunk for the good guys. I think that Kavanaugh and Barrett and Roberts are uncomfortable with what the plaintiffs are asking in this case. But I also think that they are sympathetic to the white families that want to take these kids away from their tribes. I mean, look, frankly, Roberts and Barrett adopted children. They feel very strongly that adoption is a positive thing and a good thing, and I don't fault them for that at all. There is some talk among the native law scholar community that could color their view of the law here. I don't know which way this case will go. I think I'm skeptical there will be a maximalist decision one way or the other. I think it's very possible, though, that 5 justices give states this right, contra federal law, to start taking away these kids and adopting them out to white families.
And then it's just off to the races with these corporations who begin to use the principle developed that allows for that to happen, for these corporations to do the same thing basically with property.
Exactly.
Let's talk about Talevski. We had you on the program, I guess it was a month or two ago, to talk about Talevski. This is ostensibly a case and Talevski himself died, but his estate is suing a nursing home because they did not essentially follow the Medicaid or rules, and it is sort of mutated into whether the I guess it's Section 1983, is it? Which allows for citizens to sue for the maintenance of federal laws and federal programs, essentially, if they're not being carried out by the state. Will you smooth the rough edges off that?
Yeah, I mean, look, you basically got it. There's this federal statute, we call it Section 1983, that gives individuals a right to sue to enforce federal laws. So, you know, the federal government's supposed to be doing this. The states should be helping out, but sometimes that doesn't work. And you or your estate, if you die, have to go to court and say, hey, this law is not being followed. In this case, this horrible facility was using awful psychotropic drugs to subdue patients. That is illegal. And so the family went to court and said, this is illegal. This cannot be permitted. Our family member had a right not to be drugged to death, and the state violated it. And so we are going to court to enforce that right and collect damages. And this was another instance of the conservative legal movement, specifically red state attorneys general, lining up to try to gut longstanding precedent. In this case, it's this law that lets people like you and me and our parents and our siblings and everybody who benefits from federal programs to go to court to enforce those rights. And the state of Indiana here basically said, actually, individuals do not have a right to enforce Medicare or Medicaid in federal court because that does not count as a law. It's just money, not a law, and money cannot be enforced in federal court. I know that sounds ridiculous, but that was their actual argument.
And the real concern here is, outside of the specific facts of this case, is that this is an opportunity to chip away at essentially the deputy status, if you will, of citizens in making sure that federal law that benefits them, and this could apply theoretically to a whole host of safety net programs that the federal government provides, states administer. It seems to me could also be like, an issue with like the EPA, for instance, right? Where maybe the EPA or some state organizations not upholding environmental laws. I mean, it can go across the board where citizens have the right to help enforce the federal statutes, because if they don't do it, then who does? Who can?
Especially under a Republican president. I mean, this case is not as important under President Biden, who's obviously going to enforce Medicaid and Medicare rules, right? But imagine a President Josh Hawley comes in and says, hey, I don't like poor people. I'm going to slash all of these Medicaid rules and let them die in hospitals. Who is going to step up and push back against that other than the individuals and the families who are suffering? And if the Supreme Court adopts the theory in this case, they would have no right to do so. And President Hawley could basically just destroy these federal programs without any legal pushback.
What was your sense in these oral arguments?
I will make a rare positive and optimistic prediction. I do not think there's a majority to destroy federal program. I think that Brett Kavanaugh sounded almost offended that Indiana brought this ridiculous argument to his court. And he doesn't often sound offended, but you even heard Amy Coney Barrett kind of rolling her eyes at this. I think this will be one of those cases that the conservatives use to set the outer limits of loony legal theories and say, okay, reel it in a little bit, because this would just destroy a federal program that has existed for 60 plus years, and do it in the most insincere and anti-textualist way you can imagine. Maybe there are 2 or 3 votes for it, possibly even 4. I find it almost impossible to envision a majority of the court biting on this case. How
much do you think, and this may come up in our next conversation because I want to talk about student loans. How much do you think that this, like, they're not immune from seeing what election results are, and they're not immune from like sort of, adding 2 + 2. And they look at the implications of abortion, their abortion ruling on this election, which I think is just the beginning of its implications, right? Because a Republican House is going to pass a ban on abortion. It's not going to be imposed because we've got a Democratic president, we got a Democratic Senate, but they're going to try and pass an abortion ban, and that's going to be out there, and that's going to end up being leveraged for future elections, I would imagine. How much do you think that they're sensitive to the what's going on in the politics, or is it just sort of like, you know what, we broke it into the bank, we got the cash, we're gonna run, we're in the getaway car now, we're just going for it?
Chief Justice Roberts cares about the politics a whole lot. Chief Justice Roberts' vote no longer matters. I think the 5 justices who overturned Roe have broken into the bank, as you said, and they are just shoveling as much money into the bag as they possibly can before the cops arrive. And this is an issue that we were all kind of concerned about or worried about when Amy Coney Barrett joined the court. Well, okay, is there going to be some political consideration of backlash here? Will the court at least try to maintain its legitimacy by taking incremental steps? We have our answer. The answer is no. They just don't care about that. Maybe there are instances where Roberts can reel them in a bit. I think this happened in the vaccine mandate case for hospitals. You saw Roberts persuade Brett Kavanaugh to uphold this mandate for hospitals, which is like the bare minimum that the Supreme Court should do. That's an instance where you can kind of see Roberts' influence, but that is waning on this court. And so I just don't think that there's going to be any real limit based on politics that these 5 justices in the majority are going to impose on themselves. They're just going to go as long and as hard as they possibly can until there's some kind of backlash that stops them from doing it.
All right, let's talk about the student loan cases. Now, about a month ago, the 8th Circuit put a temporary stay on this case. It was a case brought by, I think, 6 Republican attorney generals who were arguing that, you know, there was a question as whether they had standing, and they had to prove that they had standing by saying that they had invested in some private loans, and there was a conversion mechanism that ended before this program kicked in, that would have basically meant that their states could potentially lose money, sort of like a bank shot loss of money, I guess you would say, under this program, which would have given them standing, and they could argue that it wasn't legit. Just yesterday, the 8th Court enjoined it, which made it a little bit less temporary, right? Or did they halt the program? And this is not to be confused with a Texas judge who also halted the program, I guess, a week and a half ago. And now I know there were 2 different authorities that President Biden could have theoretically done this. One was under the HEROES Act, passed in the wake of 9/11, which said that the Department of Education, under the auspices of the presidency, could forgive debt if it was connected, important word apparently, to any type of national emergency, which would have inhibited people's ability to pay back that debt. Connected as opposed to concurrent with. So that, like, you know, you could argue that was the auspices in which this loan forgiveness happened under the HEROES Act. Is that what made this susceptible to these challenges, or was it something else?
These judges were always going to find a way, I think, to block this law. I mean, I think you can, or this program, and you can see that because they're concocting these ridiculous theories of standing. And you laid out one, like Missouri has this student loan processor that has the name Missouri, the word Missouri in its name. It's called like the Missouri something something. It's not a part of the state. It's not a state agency, but the state of Missouri somehow persuaded the 8th Circuit that it is, and got this preliminary injunction against the program. And I think it's worth noting, this injunction, it was 5 pages long. The number of sentences devoted to analyzing whether this program is actually legal, 0. The Eighth Circuit devoted 0 sentences to analyzing whether student loan debt relief is lawful. Instead, it spent 5 pages explaining how this was such a big deal that it had no choice but to put it on hold indefinitely. That is not a court that will care exactly which statute the Biden administration uses to justify student loan relief. That is a Republican court that is hungry to halt this program by any means necessary and will not even bother to justify its decisions on the basis of law because it has the power to step in and do whatever the hell it wants.
In Texas, the judge used the major questions doctrine, which you've talked about on this program. It is a made up whole cloth in only existence in the past 9 years. And there's no definition of what constitutes major in the major questions doctrine. It really just seems to be like, well, when we think something's like important, then it is.
This is going right back to law versus policy. The major questions doctrine is a policy veto over laws that conservative judges don't like. They don't like the Clean Air Act. Major questions doctrine, shoot it down. They don't like student debt relief. Major questions doctrine, shoot it down. Elena Kagan called it a get out of text free card, and I think that's exactly right. I don't really understand how any one person can decide what is major or not. I had thought that the court simply had to say whether Congress passed this law and allowed this regulation or not. But we're in this new era thanks to the Supreme Court's decision over the summer in West Virginia versus EPA that gives these conservative judges a new tool to just do whatever the hell they want. And that's what this judge in North Texas did. He is a Trump appointee. He is one of the worst. He barely even pretends to be a judge much of the time. His theory of standing was even worse than Missouri's, but he still decided that this program was a major question, so it had to be authorized by Congress. He quoted some CNN article in which Nancy Pelosi said this had to be done by Congress and said, well, that's enough to prove it's a major question. Congress got to do it. They didn't, so I'm blocking this nationwide.
So that has nothing to do with the authority. And we should say in the American Rescue Act, Congress did actually say that you can forgive this debt and it doesn't need to be subject to income tax. So Congress contemplated the forgiveness of this debt. Congress contemplated that the president had the power to do it, because why would you essentially do some of the cleanup for an act that you think is not authorized to do in the first place? Right? Like, why would you say debt forgiveness from the president will not be subject to income tax over the next 3 years if you didn't think the president had the authority to do that?
Right. We call that legislative ratification, and it's a huge issue in this case. It's so obvious that Congress envisioned student debt being relieved because, as you said, it exempted student debt relief from income tax for the next 4 years, a time-limited period in which it clearly expected student debt to be relieved. There was a very similar issue in the eviction moratorium case. You remember that case when the CDC had the eviction moratorium? Congress, in one of its COVID bills, identified the CDC's eviction moratorium and actually extended it by law and said, we like this and we want the CDC to keep doing it. And yet the Supreme Court still said that Congress had never approved an eviction moratorium. So it's all Calvin ball here. You cannot look at the words of these laws and look at what the courts are doing and find a clear connection. You see these courts imposing their very clear policy preferences, which are debatable. Reasonable people can disagree, but very little of this counts as true legal analysis. And most of it is just the Republican Party platform being implemented through the courts.
Again, I ask this because there are some in some circles who are arguing that the Biden administration purposely contemplated that the use of the authority that they're using would be shot down, and that there's some other bulletproof authority that they could have used if they really wanted this to happen, which is not to say that they won't try, because they've already made like multiple changes to this program once the legal threats to it became apparent, including stopping the conversion of public loans into, or private loans into public loans, and changing, you can opt out of getting debt relief so that nobody was obligated to get debt relief, which was one way that they avoided some people having standing. So they've been doing this, and they could probably find a different authority in which they would deal with it. But I don't understand, like under the major questions doctrine, how does the authority in which they're doing it make any difference anyways?
Right. I agree. And I have a different read on what's going on here. So all of these decisions so far, the two decisions, have blocked mass debt relief by Biden, right? They have said you can't issue this sweeping, all-encompassing student debt relief, this one-time program. And that leaves a lot of wiggle room for the Biden administration to adjudicate these debt relief requests on a case-by-case basis. So let's talk about the HEROES Act. As you said, this was passed in the wake of 9/11. It is not strictly limited to 9/11. It talks about national emergencies. It defines national emergencies as whether the president has declared one. President Trump declared a COVID emergency that has not been undeclared, so it's still going on. And there is almost no way that a federal court could stop the Department of Education from looking at these applications one by one and stamping them with something that says, this person was negatively affected by COVID and we are hereby relieving their debt. There is no court order right now that stops the Biden administration from doing that at this moment. And there is no rational justification under the HEROES Act for any federal court to step in and block individualized student debt relief. So my guess is that what the Biden administration did was take this moonshot initially, say, well, we're just going to see if it works, get as many people as possible to submit their application, so gather the data, and then eventually, once this is worked out through the courts, start going person by person and relieving their debt on a case-by-case basis instead of all at once, and that'll be the end of it.
Were they collecting enough data? I mean, because as far as I understand it, Matt, wasn't it just like you put your name in and your phone number?
Yeah, maybe email too.
I mean,
so they reach out, they have your contact information. I think it's quite possible that they reach out to you and ask
they send
you,
like a one-question questionnaire. Were you harmed by COVID financially? A, yes. B, no. And if you say yeah, A, then boom, you've qualified individually.
Exactly. I mean, that's how the eviction moratorium worked. You had to sign a little piece of paper that said, if I am evicted, I will spread COVID in between the states. Like millions of people did that and did not have a problem with it. I foresee a very similar process for this. It will take a really long time. It will be very cumbersome. Some people will inevitably fall through the cracks, but there's just no way that a federal court can tell the federal government that it cannot discharge this debt that it holds. You know, the federal government is holding this debt. It gets to decide what to do with this debt. And if it has to go through person by person rather than all at once, I think that's something that the Department of Education is ready to do.
And let's be clear, if they were to do that, what capacity would the federal government have? I should say, what ability would the federal government have to do anything in terms of its books? I mean, like, right. How do you justify raising taxes? How do you justify doing anything?
Right. And I mean, the HEROES Act makes it very clear that you can discharge debt. Now, the question is whether you can do it on a mass scale. Courts are going to rewrite the law to say no. But as you said, there's all kinds of other laws, like thousands of them, that give different federal agencies the ability to manipulate monetary funds that are held by the federal government. And if federal courts intervene here, there's no logical limit to where they'll stop. They're just going to keep doing this. I don't think that the Supreme Court wants to spend the rest of its time on this planet adjudicating every penny of federal money that is spent or relieved or canceled. So I just don't see a way around this for even the most radical federal judges.
All right. And so when do you anticipate this getting up to the Supreme Court?
We don't yet know.
In its current form. I
don't know if the Department of Justice will appeal the Eighth Circuit's preliminary injunction to the Supreme Court. Maybe it will. I could understand political considerations. If I were a DOJ, I would think very carefully about working this out in the lower courts while you're still collecting all of this data from individuals, encouraging people to submit applications, go to trial in the lower court.
They've stopped it. My understanding is they've stopped the applications as of a good day or two ago.
Okay, they didn't stop it initially. I guess they've stopped it.
I think
recently.
they stopped it. I think they stopped it in the wake of the Texas ruling.
Well, they should continue because that is the information that they're going to use if they're going to get anything done here. But I think there's a good chance that the Eighth Circuit decision will get appealed to the Supreme Court and we'll get a decision on the shadow docket sometime before New Year's.
Okay, and all right. So lastly, let me ask you one other question. the investigation on the leak. The last we heard, Alito said it was a betrayal, and it was a very open-ended saying if it was a betrayal. It was a question asked at the Heritage Foundation, which, in my opinion, and maybe it's a function of my conspiracy-addled mind, was a question that he invited. It wasn't. I get the sense that Alito doesn't go to the Heritage Foundation and they ask him surprise questions. And maybe I'm wrong about that, but I find it very, very hard to believe that a Supreme Court justice is going to the Heritage Foundation and they're, springing questions on this guy in a public forum. And so he clearly wanted to address it. He referred to it as a betrayal, which to me, this was my take, I'm curious as to yours, is his way of saying this was done to me. Because he went on to say, we got death threats because of it, ignoring the fact that Sonia Sotomayor had a death threat, a year before, ignoring that 15 years ago, John Cornyn, was on the Senate floor going I can understand why people want to attack federal judges, because of their rulings. He made it it sounded to me like he was setting up a narrative where they were as victimized by this as anybody else, which I find to be a little bit rich, because it ultimately probably locked in maybe a couple of votes that were wavering. At least that, in my estimation, was the agenda. What's your sense of that? And have you heard anything in terms of when the timing might come?
Only what you have heard. I do not think we will ever get a definitive result of this leak investigation. I think it's a lot of theater. I think that they're going through the motions. I don't think they will find an answer. And further, I agree with your speculation that this is more likely than not a leak from conservative chambers that were designed to lock in Brett Kavanaugh's vote with the majority. I mean, remember, a week before the draft came out, the Wall Street Journal clearly got a leak and wrote a whole editorial saying Brett Kavanaugh shouldn't waver and should stick with, the maximalist decision rather than going over to John Roberts' compromise. So I just think the whole thing is ridiculous. I doubt we'll ever get an answer. People like Alito will use it to justify their endless grievances. The rest of us will probably forget. I don't think it will become a normal thing that happens all the time. I think this was a one-time only thing in a very major case, and we'll never really know. And that will allow Alito and Thomas and all of those conservatives to continue to act like they are the real victims of the Dobbs decision.
I will never forget. I'm going to talk about this ad nauseum until the entire audience has passed on and they have no idea what I'm referring to. But that's what's going to happen around here. Mark Joseph Stern, thank you so much. Senior writer at Slate.com. We'll put a link to all of your writings so that people can further understand these things. Hope to talk to you again soon for the next round of really disturbing decisions that will be coming down from this court.
I would say I look forward to it, but I frankly don't.
I understand. Believe me. I appreciate it, Mark. Thank you so much.
Thanks.